Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In this episode of the Labour Justice Barometer, we highlight the key features of the Labour Law Amendment Bill, which was published in February for public comment. This includes safeguards for so-called zero-hour contracts, implementation of the Constitutional Court's decision in Van Wyk regarding parental leave, and proposals to strengthen the CCMA's enforcement powers and expanded jurisdiction in harassment disputes. Significantly, categories of workers previously excluded from protection are also brought within the scope of at least some of the provisions of the BCA and the LRA. And at the same time, the bill proposes limited exclusion of employees from protection during probation and places restrictions on the remedies availability for high-income employees. Alongside this, we reflect on the growing role of mediation in dispute resolution and managing conflict. As courts and labour dispute institutions come under strain, mediation is increasingly viewed as an important mechanism for improving access to justice and resolving disputes more effectively.
Thanks, Aisha. By way of context, these the Government Gazette of 26 February, and we'll leave a link in the episode description. These have been proposals for amendments that have been long in the making and are viewed as being quite an extensive range of amendments. So there are two bills in the Government Gazette. One is the Employment Laws Amendment Bill, and the other is the Labour Relations Amendment Bill. The Employment Laws Amendment Bill, this has 27 clauses, and this addresses all other pieces of legislation, including the Basic Conditions of Employment Act, the Employment Equity Act, the Unemployment Insurance Act, and the National Minimum Wage Act, whereas the Labour Relations Bill deals only with the Labour Relations Act amendments, of course. So the Labour Relations Bill is quite extensive. It has 46 provisions for proposed amendments, and the Employment Laws Bill has 27 proposed amendments. So Aisha, perhaps in a nutshell, you can give us a high-level overview of the changes that would be brought about by the Employment Amendment Bill.
I think our reforms fall into four main categories. And so if I have to look at it, I think the first one is that the bill introduces new protections for workers, as I mentioned, in more precarious forms of employment. So particularly so-called on-call or available for work employees, which many people would recognize as a form of 0 hours or unpredictable scheduling. So now employers would have to specify in writing things like maximum hours, periods employees must be able to work, and the notice required if that work is cancelled. And importantly, if these shifts are cancelled without notice, reasonable notice, the worker still has to get paid. So the aim here is to introduce greater predictability and income security for these vulnerable workers. Second, like we mentioned, there's significant reforms to parental leave, which largely respond to the Constitutional Court's decision in Van Wyk. And for our listeners, we recently discussed the Van Wyk decision with Debbie and Kitty in our January episodes, and I'd also invite you all to read Debbie and Kitty's article on this. But the bill proposes a more streamlined and gender-neutral parental leave framework, allowing up to 4 months of parental leave per child, which can be shared between parents in certain circumstances. And the related provisions in the UIA, the Unemployment Insurance Act, are also amended so that parental benefits align with this new framework. So broadly speaking, in this instance, it's about bringing the case law in line with our constitutional equality principles. Thirdly, I would say that the bill strengthens enforcement and compliance mechanisms across employment statutes. So it expands the powers of labour inspectors and the CCMA. It allows union representatives to accompany inspectors and creates faster mechanisms to enforce compliance. And another aspect that our podcast actually looked into was labour inspectors. I think it was our first episode of the year, so I'd highly recommend also revisiting this as well. And then finally, there are a number of targeted technical adjustments across the statute. So the bill clarifies how wages are calculated under the National Minimum Wage Act to ensure that deferred payments like retirement contributions are not counted towards minimum wage. And under the EEA Employment Equity Act, it expands the ability to actually refer harassment-based discrimination disputes directly to arbitration at the CCMA. And of course, our two big amendments that maybe our employers may not be too happy about. When it comes to severance pay from 1 to 2 weeks for retrenchments, and then of course that expanded definition of an employee, which I think you'll probably go into more detail. So I think overall the Employment Law Amendment Bill is doing a few things at once. I think they're responding to our constitutional developments like Van Wyk, but I think they're also strengthening protections, they're improving enforcement mechanisms, and I think updating a lot of technical aspects of the employment statutes. Debbie, that's the Employment Amendment Bill. Perhaps you can give us an overview of the provisions of the Labour Relations Amendment Bill.
Thanks, Asha. Yeah, so to pick up where you left off there, the two aspects that employers might not be too excited about, the severance pay and the expanded definition of an employee, which obviously both are intended to protect vulnerable categories of workers. And I'll get back to the expanded definition of an employee in a minute, but maybe just to pick up on what have been perceived as employer-friendly provisions. So really, I think the act should be viewed as a trade-off between improving protection for vulnerable workers and at the same time providing for employer provisions that give the employer some relief. So let me talk about some of those first. The first is quite a significant amendment that's proposed to the unfair dismissal jurisdiction, and in fact exempting new employees from the scope of the Act for unfair dismissal protections for a period of up to 3 months. So any new employees cannot rely on the provisions of the Act in terms of dismissal, and this could even be longer if the employer has put in place a reasonable and operationally justifiable probationary period. So I think this is quite significant, and in many ways aligns with foreign jurisdictions, and is often pointed as being part of the strict compliance with unfair dismissal law from day one. Has really been. We hear that that's a reason why businesses don't easily employ new employees. And then for small businesses, there's also some relief there in terms of amendments to Section 32, which would allow any new business that's just been established during the first 2 years of operation, as long as their business has less than 50 employees, to not have to comply with any collective agreements concluded in a relevant bargaining council that would otherwise have covered that employer. So just perhaps also just to take a step back and look at what the high-level themes were that informed this labour law amendment process leading to these proposals. They did include responding to changes in the labour market and the nature of work, which really relates to the zero-hour contracts and the expanded definition of an employee, which I'll get to in a minute. And then also enabling economic growth and sustainability for small and new businesses. So these provisions should be seen in that light. There are also additional restrictions on remedies for so-called high-pay employees or employees earning above a threshold that will be prescribed. I think the figure being discussed is around 1.8 million. So your high-pay employees, there would be a restriction on reinstatement. Reinstatement as a remedy would only be applicable where there are discriminatory dismissals or automatically unfair dismissals. And then also greater fairness in terms of compensation, not necessarily being pegged to a person's salary, which often negatively impacts a low-paid worker, but also placing a limitation on a maximum amount of compensation, which can, of course, bring some relief to employers. And then just maybe a high-level overview of what some of the key themes of other areas being addressed. The provisions relating to secret balloting and the standards that trade unions need to apply when secret ballots need to be conducted. The provisions that rectify a few issues in terms of the appointment of judges to the Labour and Labour Appeal Court. There are a number of provisions regulating the Essential Services Committee and the work of the committee, and relating to minimum service level agreements in terms of the provisions of the Act. And then also some financial reporting standards for trade unions and employer organizations and bargaining councils and other organizations in terms of the Act. So a lot of the provisions are standardizing and ensuring that our labour law is fit for purpose in terms of changing standards. Also some provisions around limiting the liability of functionaries under the Act, which would align the Act with other statutory functionaries and the protection that they have. And then quite a big a chunk of the amendments relate to simplifying dispute resolution processes. And these really fall under the theme of the amendment around identifying bottlenecks in dispute resolution systems and adjudication systems and dealing with that. And then also, reducing levels of disputes and simplifying dispute resolution processes and removing duplication of functions and processes. So we see quite a lot of the provisions relating to streamlining the dispute resolution functions, for example, between the CCMA, bargaining councils and accredited agencies to ensure that outside of the CCMA, provided they're accredited for it, these other dispute resolution agencies can perform all of the functions under employment law. And then also this should also assist employees by allowing for agreements in a contract of employment for the CCMA to conduct an inquiry into conduct and capacity cases, which will then do away with the need for arbitration if there is a dismissal or an unfair labour practice resulting from that. The CCMA also is tasked in the amendments to play, I think, a much more interventionist and preventative role in terms of addressing conflict in the workplace and promoting positive workplace relations, and more generally around promoting decent work and collective bargaining. And some of those jurisdictional pitfalls that must surely be frustrating both employers and employees have been dealt with by limiting duplication of claims, by allowing the CCMA commissioner to hear matters even if it wasn't initially referred, by allowing judges to also deal with any jurisdictional shortcomings that may have happened much earlier on in the process. And all of this, of course, to promote the principles that we would call these labour justice principles, but just around efficient resolution of disputes. So I think there's a lot in there that hopefully will improve the efficiency of our labour market institutions.
You're listening to the Labour Justice Barometer, and we'll be right back.
And then just getting back finally to the extended definition of employee and employer, which you've mentioned in the context of the Basic Conditions of Employment Act. This also comes in under the Labour Relations Act. In the Labour Relations Act, it's a new Schedule 11, and it's an extended definition of employee and employer for purposes of freedom of association and collective bargaining. Whereas in the BCA, the same definition is used to provide for sectoral determinations to be issued in terms of the provisions of Chapter 8. So that could determine the conditions and terms of employment. And this is really to the extended definition would to some extent provide for protection for categories of workers that we would call gig workers or platform workers, and it sets up a presumption of employment. So another term which the ILO will use in its categorizations of workers is dependent contractors. So although they, regardless of the form of the contract, they enter into independent contracts or commercial contracts, but they're very much dependent often on one employer or possibly two or three, which can be a platform, a digital platform, and it creates a presumption of employment if these are natural persons who are working personally, providing their personal services under the control and direction of the employer, and also performing work for customers or clients of the employer.
I think you did a very good job at covering that up in a nutshell, Debbie, considering there's a lot to actually get into. But Debbie, just as an aside and something very exciting, you've also been involved in developing a Mediation Act for South Africa. Can you tell us a bit about that and what that might actually mean in terms of access to justice?
So, Asha, this is work with the South African Law Reform Commission published a paper in January last year, which contained provisions for a draft Mediation Act for South Africa. And it's really, it's outside of the scope of the world of work, so not strictly in the labour justice field, but the bill certainly builds on the idea of mediation by the CCMA in terms of labour disputes. There's a recognition and a bit of a crisis, really, especially in the Gauteng and Pretoria division, around the inability of courts to get to their matters. I think matters were being set down for 2031, 2032, so you're waiting 7 years before your matter gets heard. And so the as an interim measure, the Gauteng and Pretoria already have a mediation directive and a mediation protocol, which requires mandatory mediation before a matter can be set down for trial. So this is very similar to the CCMA, similar in some ways, but different because it's integrated into the court processes rather than in a different institution like the CCMA. And the idea behind the Mediation Act would be to introduce provisions at a national legislation level for mediation to roll out as a dispute resolution process in certain civil litigated matters. So I think that's a space we need to watch, and what that will mean in terms of the mediation profession and the demand and requirement for qualified and competent mediators in a number of fields, and not just labour. So actually, I think these are both, the labour relations amendments and the move towards mandatory mediation. These are quite big developments and shifts that in some way or another will impact on the world of work and our dispute resolution processes more broadly. So coming to our final question, of course, from your perspective, how do these developments register on the Labour Justice Barometer?
Well, Debbie, I think if I had to place it, I'd definitely situate most of these developments in the orange to green category. There's certainly aspects of the bill that represent meaningful progress. Reforms to parental leave, which is an important response to Van Wyk. I think, looking at more unified and gender-neutral parental leave and, recognizing that caregiving responsibility shouldn't be structured in a way that only reinforces traditional gender roles. But, as we discussed with Kitty in our earlier episode, even that reform still leaves some practical and structural questions unresolved, particularly in relation to the UIF benefits and the realities that are faced by lower-income workers. So I do think it's a step forward, but I think it sits more in the orange space. I think looking at, for example, the on-call or available for work employees, it's a significant acknowledgement for the precarious work and when it comes to unpredictable scheduling. But requiring employees to specify availability periods, notice requirements, compensation, all of this introduces an important measure of income protection for our vulnerable workers. And I think the bill also attempts to strengthen enforcement mechanisms across the employment statutes by expanding the powers of labor inspectors and allowing union representatives to accompany these inspections and just creating more efficient pathways. So I think, there is a lot in terms of enforcement mechanisms and progress when it comes to addressing a lot of workplace rights that exist on paper but are difficult to enforce in practice. But Debbie, my concern is also around the burden. A lot of this might also place on our CCMA, especially in terms of resources and the capacity. I think this is why I say it sits in the orange. As with many labour law reforms, the real test will lie in implementation and whether the institutions responsible for enforcing these rights have the capacity to do so effectively. But what are your thoughts on this, Debbie?
Aisha, yes, I think I'm optimistic about the provisions. I think they can go a long way towards, certainly in the labour relations amendments, towards streamlining dispute resolution. You raised the issue of the CCMA and a potential increased burden, which I think has, been the CCMA's experience. It has had to grow, and its own success has meant that its jurisdiction has grown. And, to a large extent, the success or otherwise of these provisions will depend on stakeholders and their ability to prevent disputes from escalating. So that matters, that less matters are referred to the CCMA and rather preventing disputes at source. So I think I agree with you too that the unfortunate exclusion here of vulnerable workers who would, entirely fall outside of the scope, for example, self-employed workers will not benefit from the UIF provisions or the maternity and paternity leave provisions that are being provided. So the red really are the exclusionary workers who still need to be brought within the scope of protection. Aisha, I think it very much remains to be seen how these two developments unfold in the months to come.
Thanks, Debbie. And I think just a reminder to our listeners that we will leave links to the bill in our description. And the bill is also available for public comment until the end of March, until the 28th of March. So, let's see how things develop and go. Debbie, I'll see you in the next one.
Thanks, Aisha. See you next time.
This podcast is not intended to constitute legal advice.